Have you ever wondered what happens when two businesses in Qatar have a major disagreement? How does a judge figure out who's actually in the right? Well, it's not a mystery at all. Turns out there's a very precise legal map they have to follow. So today, we're going to walk through that exact map, drawing on the great work of legal scholar Dr. Nasser Al-Adba to really understand the sources of Qatari business law.
So, let's put you in the situation. Imagine you're in a serious business dispute, and you end up in court. The judge is looking at two totally different sides of the story. How in the world do they find the right legal path to a fair decision? It's definitely not guesswork. There's a very specific, mandated roadmap they have to follow.
And here it is. The answer is spelled out right here in Article 2 of the Commercial Law. You should think of this quote as the master key. It sets up a super strict, non-negotiable hierarchy of rules that every single judge must follow. This right here is the foundation for everything else we're about to get into.
Okay, so who exactly is this legal map for? Well, its reach is actually incredibly wide. Of course, it covers merchants, that makes sense. But it also covers any and all commercial activities no matter who's doing them. So whether you're a big registered company or just an individual making a business deal, this is the framework that applies.
And when we say this path is mandatory, we mean it's absolutely mandatory. A judge can't just pick and choose which source they like best. Nope, they have to follow this exact sequence. First, they have to look at the written commercial law. If there's no answer there, then they move to step 2, commercial custom, which is all about how business is actually done. And only if both of those come up empty can they turn to the civil law. It's a strict, one-way street. No detours allowed.
All right, let's start walking down that mandatory path. This is Section 1, the official sources of law. And these aren't just suggestions. For a judge, these are binding commands. The judge's very first and most important stop is always commercial legislation. This is the big one, the primary, fundamental source. Before a judge can even think about looking anywhere else, they have to search for an answer right here, within the written laws governing business.
So what do we actually mean by commercial legislation? Well, it's not just one single book. It's a whole library of specific laws, everything from the law on companies to trademarks to patents. And if a rule exists in any of these, the judge is obligated to apply it. End of story.
But what happens if that entire library of written law doesn't have an answer for a specific dispute? That's when the judge moves on to the second mandatory stop on the path, commercial custom.
So what on earth is commercial custom? Just think of it as the unwritten rules of the game. It's the way business has been done in a certain industry for so long and so consistently that it's become an expectation, a rule that's just as powerful and just as legally binding as a written law.
Now, not all customs are created equal. You've got general custom that applies everywhere in the country, but more importantly, you have special customs for specific industries, like, say, car dealers, or local customs for a specific city like Doha. And here's the really crucial part. The more specific rule always wins. A custom just for car dealers will always trump a general business custom.
You're probably wondering, how do you prove an unwritten rule in a courtroom? It's not just based on what someone says. The court needs actual evidence, like testimony from experts in that industry or official certificates from groups like the Chamber of Commerce. That's how they formally establish that a custom is real and valid.
Okay, now we've reached the final mandatory stop. If there's no specific commercial law and there's no established commercial custom that fits the dispute, only then can the judge turn to the civil law. It basically acts as the ultimate legal safety net, making sure there's always a rule that can be applied and a way to resolve the issue.
So that's the whole mandatory journey. But the judge's toolkit isn't empty just yet. Now we're moving into Section 2, which covers a totally different type of source, the persuasive or non-binding sources of law.
And the key word here is discretion. Unlike those first three sources, these are not commands. A judge can look at them for a little guidance, maybe some inspiration on a really tricky point of law, but they are never, ever forced to follow what they say.
So what are these persuasive sources? Well, first, you have judicial precedents. These are past decisions made by other courts in Qatar. They can offer some really valuable insight. And second, you have jurisprudential opinions. That's the scholarly articles and books written by legal experts, like Dr. Al-Adba. Both of these are there to serve as a guide, not a rule book.
So why does any of this matter to you? The really crucial takeaway is this. This strict, predictable hierarchy isn't just a rule for judges. It's for everyone doing business. It creates a stable, transparent legal system where the written law comes first, giving you certainty, and where industry practices are respected when the law is silent. It means you know the rules of the road before you even start your journey.
And that leaves us with one final thought to chew on. In a world that's changing so fast, with disruptive tech and new business models popping up all the time, does a rigid legal hierarchy like this one provide a stable foundation? Or does it risk becoming a barrier to innovation? Something to think about.